So hi guys.
Hi.
Have you all heard the case of the Republic versus Achala? Would you like to hear about it? So in this case, a guy called David Achala murders his girlfriend called Fiona from a quarrel they were having. So immediately after the guy, apparently Fiona and David Achala lived in the same compound. And all this one day, the day of the quarrel, um, Achala had invited his friend, and after murdering Fiona, he called the friend outside and he wanted his friend to help him cut the body into pieces and burn the body. Can you imagine? Yeah, I know it's crazy. So the friend obviously startled because to me I would startle too. So he reported the matter to the police, police officers, and when the police came, they found the chimney smoking with the soft smoke from the chimney, and they found the body of Fiona, which was partially burnt, and they arrested David Achala. So at the courtroom, um, David's defense was he was not completely sane at the moment. Like his brother claimed that he had previously been diagnosed of schizophrenia, a mental disorder, which could have had an influence in him murdering Fiona. So at the proceedings, the court decided that there's no way that an insane person would think of covering the murder. There's no way an insane person would think of cutting the body into pieces and, burning the body. So instead, the judge came to a conclusion that the only applicable principle in this case was diminished responsibility.
Wait, what exactly is diminished responsibility?
So diminished responsibility is a partial defense as set out in the section 4A of the Offences Against the Person Act. This is when somebody's mental condition impairs their judgment when they are committing this act, and in our country it is a partial defense for the murder charge, but in other jurisdictions it can be used for other offenses. And it is also a partial defense in that when a person uses it as a defense, they're not fully acquitted from their charge, but some of the repercussions are taken away. Yeah.
Okay, but where exactly did diminished responsibility come from?
Okay, so diminished responsibility is believed historically to be from Scottish law. They actually have the earliest case on record to have used diminished responsibility to decide a case. This is a case of Sir Gordon, who murdered his brother, but in the end, the judge decided that he was not fit for death by hanging. They decided to actually put him in a secure location instead of killing him, because they believed he was suffering some mental disorder that in some way cut. In some way, it limited his way of thinking. He couldn't conduct himself out of his own accord. Yes, and so they actually sort of differentiated diminished responsibility from insanity in a way, because diminished responsibility was a lower form of insanity. Someone was not fully did not meet the qualifications to be insane, so they were diagnosed with, let's say, other mental disorders that in some way limited how they could conduct themselves. So yeah, that's technically what differentiates diminished responsibility from insanity as well. Yeah.
Furthermore, intoxication can also be a relevant factor when assessing a person's responsibility for a crime. While it can impair a person's ability for the required mental state of the crime, it does not actually negate the defense of the crime. So intoxication can be of two types, that is voluntary and involuntary. So under voluntary intoxication, it's not actually a defense because one is aware of what you're doing. Yeah? You learned that during criminal responsibility. Okay, so and the next one is involuntary intoxication. So here there's no aspect of mens rea covered. So it can form a defense but does not actually mean that it's a defense. Yeah.
Oh, and also, for diminished responsibility to be satisfied, there has to be some things. First of all, abnormality of mental functioning. So this person is not in their normal state, they're in the abnormal state. And then now the second thing is now the abnormality, it must rise from a mental condition. For example, PTSD or battered wife syndrome. You remember the case of Trufen in legal system?
Yeah.
That one. And also, as she stated, she said the guy had been diagnosed by schizophrenia. So now you see the person is not in the right mental state. Now the third thing now is now the person, there has to be substantial impairment responsibility. Like the defendant was unable to understand the nature of their conduct. Like they don't understand what they're doing. They don't have self-control. And also he wasn't, the defendant, he or she wasn't able to think logically. And then on the fourth thing now, you have to provide an explanation for the killing. So now in explaining the explanation, the abnormality can be a cause to the killing, or maybe it can be a significant factor to cause the killing. And so maybe you might ask me, okay, now how is it proven in court? So now the burden and standard of proof lies on the defendant because it's a partial defense. So now the standard is on probabilities, and then also medical reports. Let's say an expert, a psychiatric expert, provides evidence now. Now that evidence is used by the defense in court to prove that this person was not in the right mental state. So it was now diminished responsibility.
So now that we've understood the elements of diminished responsibility, let me now take you to the fascinating facts of Michael Brennan versus the Crown. So, a brief background to his life. He was a depressed person from 13 years, and he had the condition of he had ongoing mental health struggles. He had emotionally unstable personality disorder and schizotypal disorder. Now to the key facts of the case. So Michael Brennan lured the victim, Paul Simmons, to a flat and he murdered him there. And prior to the crime, he had planned the crime on a laptop. And from the crime scene, they found murder weapons and scribblings on the wall relating to Satan and thereabouts. So the court found that from the evidence of the experts, they concluded that the actions of Brennan were not generated from his own thoughts, they were from the disordered thoughts in his mind. So they were able to replace the verdict of murder with manslaughter because from proving that he suffered from these mental recognized conditions, he met the threshold for diminished responsibility.
So from all the cases we've had so far, diminished responsibility doesn't only lie on murder cases. It can also be applied in sexual offences cases where the defendant for example, in sexual offences cases where the defendant has to prove that the accused I'm so sorry. For example, in sexual offences cases where the defendant has to prove that the accused was mentally stable to have committed the sexual offence acts, and if they're not able to prove that, and more medical reports show that the accused was depressed or had prior mental issues before that, then the case can be ruled in favor of diminished responsibility. Also in theft cases and in manslaughter cases as well, as said by Pendo.
So from what my learned friends have cut. So from what my learned friends before have said on the case and the burden of proof, we've established at least 3 conditions for diminished responsibility to apply for it to be a successful defense. So that is, the accused must suffer from an abnormality at the time of killing, and the abnormality arose due to disease or retarded development, and the link between abnormality and the cause of death must be established. So one might ask the question whether one may act crazy or play mad for a successful defense to apply. Cut.
I feel like hapo mtu anaweza. Oh, by the way, say
Nice. So one can ask the question whether someone might play mad or act crazy to be acquitted of the charge or reduce the charge to manslaughter rather. So, but that doesn't really apply because emotions such as jealousy and anger can be shown from time to time. And rather this defense focuses on somebody that has been established by a medical practitioner to be actually abnormal rather than pretend.
So, and on the point of criticism of diminished responsibility, the first one is the victims of the murdered people. For example, if a person was murdered, then the family members or relatives do not get the justice they want because they say that the violent criminals who killed their family members were given lighter sentences, they were sympathized upon, so it's unfair to the families. The second one is that it is considered a loophole for criminals. So a violent criminal can be sentenced from, the sentence can be reduced from murder to manslaughter, which is also unfair. The third one is a person can pretend that they have mental illnesses, and since the legal procedures of the medical procedures of identifying the medical condition is expensive, it is quite inefficient. The fourth one is also that the judges do not understand those medical terms. They are not doctors, they are not medical experts, so they can in order to decide the medical conditions, they have to rely on the medical experts, which is also inconvenient. And yeah, those are the case.
Okay, I think it's also fair to add that in Kenya it hasn't really been recognized as much. Various judges have tried to sort of induct it into a system, but they haven't really done it properly, except now since 2024 through the Achola case that we've been given. It mainly applies to other jurisdictions, especially now regarding it applying to other offenses. It depends really on the jurisdiction under which it's being applied, but Kenya hasn't really developed that defense to its best capability. Yeah.
So this has been Form 9. We were happy to teach you diminished responsibility. We hope you got something. In case of any question, feel free to get to us. Bye.